So one of the most common inquiries for investigations is how to get private information, how to get bank account information, how to get somebody's social security number, how to get somebody's asset information, even vehicle information. Maybe you want to get some of their emails or something private from the person. The problem is there's ways to do this that are legal and there's ways to do it that are illegal. Most of the requirements for how to obtain information comes from what's called the Gramm-Leach-Bliley Act. And this was originally passed in the 90s, been updated a few times since then, and it regulates what an investigator or even a private person can do to get information, called pretexting. The prohibition against certain techniques has been expanded, and it was just expanded again. That enhanced blocking of research was upheld by a federal court. An expanded interpretation of the Gramm-Leach-Bliley Act, pretexting. What that means is, if you want to get information about somebody for a court case, for assets, for a divorce case, you have to make sure that you do it properly, and even if somebody else does it for you, that they do it properly. Because if they don't, it could create liability for you, for your case. Even using the information might be blocked, and you might have to pay sanctions or damages. How much damages? Well, it gets pretty severe. Let's take a look. First of all, let's talk about what the language of the law says. It says you cannot use deception and false pretenses to collect personal information about a client. Okay, so that's pretty simple. Primary method used to collect information involves a form of what is known in the private investigative trade as pretexting. And that's one of the methods that some investigators use. A lot of investigators thought this was okay, but the House report says that if you are doing this, you are no longer operating in a gray area of the law, but are instead engaged in conduct that is explicitly proscribed. That means no good. It's considered to be a fraudulent and deceptive access to financial information by misrepresenting. So if you are in need of private information, be sure that the methods used are appropriate so you don't run afoul of these rules and not only not get the results you want or not be able to use them, but you don't want to create more liability for yourself. We had a case that we talked to a colleague about where the client had won a judgment against another person for about $400,000. And they wanted to collect on that judgment. In order to collect on the judgment, they wanted to find assets. They wanted to find bank accounts and other assets. Well, the method they used to find these bank accounts and assets was illegal pretexting. When the debtor, the person who owed the money, found out, they used that knowledge to go back to court and not only undo their $400,000 debt, but get payment from the creditor. So the creditor went from being owed $400,000 to have to pay $30,000 just because they did something wrong. And in that case, I believe that they didn't even know what they were doing was wrong. Again, it said right in the article, many private investigators think it's a gray area. It's not a gray area. It is something very clearly prohibited under the law. And there's a lot of techniques that people use that they think are okay, they think might be clever, they think might be slick, but it's not going to pass muster. And if you need to use this in court to get a writ of garnishment or to use some other court procedure to get your money back, if it's discovered that it was done improperly, not only are you not going to get your money, but you might owe money to the other side.